Hi, everyone. My name is Jenny Hergenrader. I am an attorney at Disability Rights Pennsylvania. I do a lot of work on behalf of families and parents of children with disabilities, specifically in the area of educational disputes. Disability Rights Pennsylvania, if you're not familiar with us, is the protection and advocacy organization in the state of Pennsylvania. Every state has a protection and advocacy organization, and our job is to protect and advocate for people with disabilities in the state. And we're largely federally funded to provide these services. And so families and people with disabilities can call us for help understanding their rights, understanding what resources are available to them, and our services are free of charge. We will try to provide helpful information to anyone that calls with a disability related question. And we do litigation in the area of people's rights. Um, we don't take every case that is a case we could do, but we have priorities that are set by our board, and we select our cases based on those priorities. But it's always worth contacting us if you feel like there is a legal issue you may need help with, particularly if it's systemic in nature or it has an important legal issue. So I put the phone number at the bottom of this slide so that you would all have it. That's our general intake number that anyone can call. Someone answers the phone from 9 to 3, Monday through Friday. You will get a live person answering. And we also have a website with a lot of resources that you may find helpful. So today we're going to talk about special education laws with an emphasis on what families' rights are during the transition from preschool to kindergarten for their child. As you all probably know by now, there are both federal and state laws that apply. The federal laws, and you don't need to memorize these or know their citations at this point. It's just important to be familiar that they exist so that as parents and families, you can look them up and research them as necessary. And so the first that I'll talk about is the Individuals with Disabilities in Education Act, or the IDEA. And that is the federal law that is specific to special education services for kids with disabilities. The next is Section 504 of the Rehabilitation Act of 1973. And that is a law that prohibits discrimination by any recipient of federal funding. So it would apply to any public school or charter school, as those schools all receive some amount of federal funding, and also at times applies to private schools and entities if they receive some amount of federal funding. And some private schools do through one of the various grant programs, such as the Free and Reduced Lunch Program. The Americans with Disabilities Act is the third federal law that's applicable to kids with disabilities in the school setting. There is a section of that act that applies in public school settings, and also one that applies in private school settings. The requirements are different for each, but it's important to know that that does exist and it is applicable. Pennsylvania's laws we refer to as Chapter 14 and Chapter 15. Chapter 14 is the special education regulations, and Chapter 15 corresponds with Section 504, the federal law that I mentioned from the last screen, that protects students with disabilities. It prohibits discrimination, and it requires schools to give students with disabilities equal opportunity. And so again, it's important to just sort of know the names of those laws and that they exist. These are links in my PowerPoint here if you're able to access them. But even if not, you should be able to find the regulations online easily if you ever need to. So what is the difference between federal and state law, and why is it important to know that they both exist? Again, as I said, federal laws are applicable to all public schools in Pennsylvania, even though it's a federal law. State law simply adds some clarification at times, or at times additional protections to what federal law already applies. So they sort of work hand in hand. They're consistent, they're very much similar in what they require, but state law can at times bolster what the federal law requires. Um, to the extent that there is ever a state law that seems inconsistent with a federal law, or that would seem to take away a right that your child has under federal law, federal law preempts state law, meaning it must be deferred to over state law if there's ever a conflict. So jumping into sort of the substance of special education, and if you are sort of new to this world and figuring out what your legal rights are in the special education world, there are 3 important steps to getting special education for your child. And they start with an evaluation of your child's needs to determine if they're eligible for special education. Once that evaluation is completed, if your child is eligible and there's no dispute about that, and the evaluation was done appropriately, you move on to IEP development, which is done by a team, and it requires that team to develop a program that's individualized and specific to the child's needs. And then following that, the school district or charter school, or private school, if you're in a private school, will then be required to implement what's in that program, the services and the supports and accommodations that have been agreed upon by the team. So when you look at this in the context of transitioning from a preschool setting, where some of you may already be familiar with an IEP, or in Pennsylvania, an IFSP, an individualized family service plan, there's a process that occurs, and we're going to kind of go through that process step by step here. This slide shows all the topics that we will cover. And I'm going to go through each step now. So the process, by February 1st of the year where your child would be eligible to transition to kindergarten, so the year where they're about to turn 5, or if they stay in preschool for an extra year, the year in which they're about to turn 6, your early intervention program, if your child is already receiving early intervention services, will send you a letter to set up what's called a transition meeting. By the end of February, you should have that transition meeting. It should be scheduled, and you should have it with both your early intervention program, which is commonly an intermediate unit in Pennsylvania, and with your local school district, the district where you live and that's responsible for educating your child. At that meeting, parents will be given the option of deciding to register for kindergarten for the upcoming year, or if their child is still young enough and could spend an additional year in preschool, then could opt to do that. Once a child is registered in kindergarten by their parents, then the obligation by the local school district will begin. So again, at this meeting, if the plan is to transition the child to kindergarten, the family and the school district should decide, with input from the early intervention program, whether the IEP that already exists can be implemented with some revisions, or uh, whether to first conduct a reevaluation of the child before determining whether the IEP needs additional revisions. And that reevaluation can be a more simple process where the school district reviews all of the existing information about the child, medical information, information from the early intervention program, and basically writes a report, their own evaluation report, based on just a review of that information, or whether the school district at that time should do additional testing and a comprehensive evaluation where they do, additional assessments of your child before writing a report. So parents and the rest of the team will make that decision about what type of evaluation is necessary, and then the district will proceed with that evaluation. If they do decide to do a complete evaluation, which I think is probably the pretty common way to go, parents will have to sign a permission to evaluate form, and then the school district will have to complete that evaluation within 60 days. Not including summer days, but if this process starts in February, as it should, that evaluation should be done before the summer so that the team can then get together and plan the IEP for the upcoming year. Parents do have a lot of rights that they may not initially realize that they have. And we see this in the process first when this evaluation is completed. If a parent doesn't agree with the evaluation that the school district completed, they can tell the school district that, and they can request an independent educational evaluation. I always tell parents it's sort of like getting a second opinion from a doctor. You want more than one opinion from an expert, or if you feel like the first doctor you saw didn't have enough expertise, or rushed, or didn't touch on everything that you believe needs to be looked at for your child, you can go and get another opinion or another evaluation from someone else who you feel has appropriate expertise. So if you disagree with the school district's evaluation with any aspect of it, what they're recommending, whether or not they think your child is eligible for special education, the extent to which they think your child's disability will impact their education, you can request an independent evaluation, and the school district can either agree to provide that, or they can go to a due process hearing to defend their evaluation. And we will talk about that more a little later. So assuming you get through the evaluation process and have a solid evaluation that you're comfortable with, or that you've gotten yourself an independent evaluation that you're also going to bring to a meeting for the team to consider, and for the team to, to benefit the team, because it will include additional information and expertise about your child. The next step of the transition is the IEP meeting. There are certain people that are required to attend an IEP meeting, and I've listed them out on this slide so that you can reference it in the future. Most schools will know of this obligation. If they don't have someone there that they're supposed to, a parent has to waive that. And it's important for you as a parent to know that you have the right to bring to your child's IEP meeting anyone who you believe has a special knowledge or expertise related to your child. It's your choice who you want to bring. You can also bring a support person or a family member if you feel like that will help you at the meeting to understand the content and to advocate for your child. When you arrive at an IEP meeting, or potentially even before the meeting, don't be surprised if the school has started a draft of the IEP. They are allowed to do that as long as they come to the meeting with an open mind, willing to discuss all aspects of the program. They can't come to the meeting with an IEP prepared and a mindset of this is completed and this is what you have to accept. The IEP is supposed to be developed by the team, which includes you as the parent, and your opinions and your insights and your preferences for your child do have to be considered by the team. So you are a member of the team, and it should be a process of the team developing the IEP together. When you develop an IEP for your child, a lot of parents wonder, what can I ask for? We get that question a lot. What am I allowed to ask for? How do I know if I'm going too far? How do I know if I'm being too pushy or demanding? What is my child entitled to? And the answer to that question is that your child is entitled to an appropriate education that's individualized for them and that will meet their needs. So it's very hard to say you can ask for this, but you can't ask for that. It's impossible to draw those clear black and white lines about what you can and can't ask for. It really depends on what your child needs and what is appropriate for them. The legal standard is appropriateness. Appropriateness doesn't necessarily mean that your child is entitled to the very best education or to everything that you prefer for them to receive, but it is a standard that has some teeth. The Supreme Court has said that appropriateness means more than a de minimis educational progress. It means that the child should have a chance to meet challenging objectives and to have ambitious goals set for them. So you will develop this plan with the team, which it's a long document with many sections. I've referenced some of them here on this slide, but you'll learn them quickly as you go through this process. Once a school district and the parent have developed this IEP, a school district has to give the parent notice, legal notice, that they plan to use this IEP for the child and implement it in the school setting. And in Pennsylvania, that is done on a form that's called a NORUP. It stands for Notice of Recommended Educational Placement. And you'll become familiar with that form. It will identify what the school district is proposing, and you will have the opportunity to decide whether you agree that they should implement this program or disagree and challenge the program in some way. If you are not satisfied with the program and you don't think it will allow your child to make appropriate progress, or you know that because your child has already had the IEP and is not making appropriate progress, you can request something called mediation or due process to try to resolve the dispute you're having. You can also always request time to have additional meetings or discussions with your school if you think it can be worked out informally. But these are additional steps where Pennsylvania's Office for Dispute Resolution is available to families to come and try to help you resolve a dispute that you're having with the school district. So when we think about this in the context of kids transitioning from a preschool program into a kindergarten program, if there is a dispute that comes up about what the child will receive in kindergarten and the parent disagrees with the NORAP, and they request mediation or due process, that will invoke something that legally we refer to as pendency, meaning that the child will be entitled to keep their former program, the last program that was agreed upon by the team, while the family is going through the process of disputing the IEP that has been proposed. And I know this is a lot of information and it's dense and complex, and that is why it's important for you to have this and to be, somewhat familiar that these procedures exist, but you should always know that you can reach out to various groups for help understanding what your rights are. You can call Disability Rights Pennsylvania. There are other advocacy centers. There are many private law firms that represent families, and you can call for help understanding your rights if you get into a situation like this where you really need specific individual advice. But you should know that there is this concept of pendency, and if you decide you're going to challenge the IEP that your school district offers you, you do that through the NORAP form by requesting mediation or a due process hearing. If you don't do that, the school district will proceed with the IEP and with implementing their recommendations. So mediation is a process where the state will send a trained mediator to help you resolve your disagreement with your school district. Sometimes it works, sometimes it doesn't. If it does work, you can enter a written agreement with the district if you're able to resolve the issue. A due process hearing is a more formal procedure that is sort of like a trial. It's called an administrative hearing, and there will be someone that presides over that hearing called a hearing officer. It's a formal hearing that requires introduction of evidence and opening and closing arguments and calling witnesses. So while it is meant to be a procedure that's accessible for families, and families don't necessarily have to have a lawyer, it is a difficult procedure to go through without a lawyer. And we typically recommend that families try to get a lawyer if they want to go through it with a due process hearing. You can contact our office to see if it's something that we can help with. And you can contact one of many private law firms where lawyers take special education cases. If a lawyer is successful in helping you with your case through a settlement agreement or through a hearing that actually has to be decided by a hearing officer, that attorney can be awarded attorney's fees for their time in the case, reimbursement of the fees that you've had to pay the attorney, so that that's not out of pocket for you. So it's important to know that because many families are intimidated by the financial nature of this if they do have to get an attorney. Just know that it's something you can talk to your attorney about to figure out if there's an arrangement that can work, because if you have a good case, you may be able to recover the fees for your attorney. So this slide shows those 3 basic steps of special education that we talked about before, and what right you have at each one of those steps if you disagree with what is happening for your child. So to reiterate, for an evaluation, if you disagree, you can request an independent evaluation. With the development of the IEP, if you don't agree that it's appropriate, or you have seen evidence that it is not appropriate because your child is not benefiting from it and not making appropriate progress, you can file a request for mediation or a request for due process to challenge the appropriate effectiveness of the program. And third, IEP implementation. Once you do have agreed upon program in place, if the school does not implement it, if they don't follow it, if they don't provide the services that they are supposed to provide your child, there is a type of complaint you can file about that with the Division of Compliance. That is one arm of the Pennsylvania Department of Education. And we can give you more information about that if you need it. You can also find information about that online. The website for the Office for Dispute Resolution has a lot of information about all of these procedures that, as a parent, hopefully you never have to utilize for your child, but you should know about and know that you have the right to utilize if you don't agree with what's occurring. So I apologize if that felt rushed. That's, as I said, so much information to take in at one time. You should feel free to reach out if you have additional questions for us, as I said. And I'm going to open up the presentation at this point to my co-presenters, Tani and Maria, so that we can discuss a couple of issues where I think the discussion will hopefully be helpful for all of you. Hi.
Hello.
So I thought we could have a discussion, since we're talking about transition from preschool to kindergarten, of what tips you might offer families who are going through this process. What are the best tips or advice that you can give those families that are about to enter the process about how to approach it and protect their child and make good decisions? Do either of you have any thoughts on that one?
Sure. I can talk a little bit. I know another piece of our presentation will also talk about, in my piece, we'll talk a little bit about advocacy and how families can become good advocates for their child. I think the transition phase is really daunting to a lot of families, and very often, as you presented, teams will come to a meeting with a draft IEP, but sometimes families think that a lot of things are predetermined, or the team will make it seem that way. And parents don't feel like they always have a voice, or they don't know what the options are. A lot of families will say to me, I don't know what's possible. So if I don't know what's possible and no one's telling me, then how can I really advocate for my child? So I think that the sticking points of transition are really difficult for families to go through.
Yes, I agree with what Maria said. I always like to remind families of two important things. One being, make sure, if possible, visit different schools and see what your options are. See if you can get a tour, see if you can bring your child along, see if maybe they can join a class just for a few hours or so, just to get an idea of what the environment is like for the child, how they respond, if they feel comfortable. And it's normal if your child would feel a little shy in that environment with other kids that they're just meeting. And the parent, of course, stays in the room with the child as well, but a little bit back to encourage the child to engage with other students. That's definitely helpful to see how your child would respond in that environment. Do they light up? Are they excited to be there? Or is it a place that they need to warm up to a little bit, but they still look like it's something they would be interested in? If so, that's great. That's a great sign. That way you'll know whether your child will have a positive reaction to that environment or not. Secondly, I also agree with what Maria said, that very often school districts show up with a rough draft based IEP that goes off an evaluation, which is fine, but also remember, it's a draft. A draft is not set in stone. So it's up to the parents and families. You have the opportunity to engage in discussion before it becomes finalized. So just because you see the draft form, don't think that means it's finalized. Also keep in mind with placement, where your child will get information, that should be the final piece of discussion during the meeting. Any discussion about goals and services, You don't want to automatically think, well, we don't have a here. That's time for a timeout. You're not talking about your school per se. These goals can pertain to any school because they're the child's needs. So when you're talking about what you see at home, needs that are happening there or also in the school, they can be written into the IEP. Especially if it's the first IEP, it's very important that parents' commentary go into the IEP so the information is there.
Thank you.
You want to make sure it's on record, just in case there's a dispute later.
Thank you for raising the issue of placement. I actually forgot to talk about that specifically, but that will of course be a big topic of conversation for the IEP team. And Tani is right to point out that that is the last piece of the discussion. And after the program is built based on what the child's needs are, what their goals should be, that is when the team should decide where can this IEP be implemented most appropriately. The law also requires that school districts place children in what's called their least restrictive environment. And for children who are deaf or hard of hearing, this can be somewhat of a complex analysis, figuring out what their least restrictive environment is. For many children with disabilities, it's defined in a pretty straightforward way, where it has to do with how much access they have to learn alongside their non-disabled peers. But for children who are deaf or hard of hearing, they may have in a school that's not an inclusive school, but instead a school that is a specialized school for children with disabilities. They may have more opportunities for socialization, for communication if they are in a school with other children who are also deaf and who can more easily communicate with them. So the analysis of what a child's least restrictive environment is can be somewhat more complicated, and involve a second step for kids who are deaf or hard of hearing, and parents should be aware of that, and so should school districts. But this should really be probably the last thing that is discussed and decided by the IEP team.
And I have seen concerns parents have with what's being presented when some teams will present only one option for where the IEP would be delivered. And as Tani was saying, sometimes you want to look at different placements. You want your child to visit placements. You may get more out of them visiting and providing feedback than just discussion with team members about what the placements can offer. Where your child feels more comfortable, or where you feel, depending on your philosophies and knowing your child best, which environment you feel is appropriate, because it's least restrictive environment as appropriate for your individualized child. And I think that's a big piece that gets lost. Certainly with professionals, they think least restrictive. We just always have to be shooting for what's the least restrictive. But you have to factor in the individual needs of that child. So I think that's important. And what Tani was saying about just making sure you're asking those questions, like you want to know what environments could be possible. Which ones did the team consider? Because that should be a discussion you're having all together. The team shouldn't have considered those options without you present and then comes to the meeting with sort of their decision or their offer. You should be part of that conversation. And if you feel like you're not, it's okay to ask other professionals in the field, doctors and treating physicians, where other parents, where other kids go, to explore your own options and maybe bring that to the table. Like, have we ever considered this placement as being appropriate for my child? And could we discuss that? Because we feel this might be a good fit. So I think it's okay for parents to do that. And very often parents, I think, feel like they're not allowed to do that, or they shouldn't, they're not encouraged to do that.
Right. I think parents tend to feel like they are outweighed at IEP meetings because there are a lot of folks there who work for the school district, and then it's just them as a parent, and they feel like it's lopsided, but really they are a valued member of the team, and they have rights under federal law to have a say in the program and dispute the program if it's not appropriate. So it's important to know that going in. And one other point with regard to placement is it's not just about least restrictive environment and what is an inclusive setting for a child, but also it has to be a placement where the child can make meaningful progress for them. The appropriateness of the placement and whether or not the child can learn there is equally important. So keep that in mind. The other question I was going to ask both of you is what disputes you see most often, either during this transition phase to kindergarten or once a child is already in school. What do you think are the most common areas of dispute?
I mean, for me, it's definitely, sorry, Tom. For me, it's definitely the placement piece and trying to consider what would be all the options first and foremost through the transitions and even throughout their career and education. It doesn't have to be just at the early intervention into school age transition phase. Placement discussions and IEPs happen every year. Is this still an appropriate place? Is my child making meaningful progress in the way that they should be? And sometimes that happens during natural transitions of a child's life from elementary school to middle school to high school, or exiting out of services. Do they stay longer till age 21? Do they graduate on time? A lot of things can be considered. I feel like during those big discussions, either the breaks during in the education system of moving from one program to another in that way, like elementary school to middle school, that's when I see a lot of issues. Also, if the child's not making the progress that the parents think that the child should be making, but the team feels that they're making appropriate progress, I see a lot of conflict during that time too.
Yes, I agree with you. And also pertaining to the last thing you said about school and parents' views being different on the child's progress, that very often, the low expectations for the children are dangerous. It's definitely a risk. We don't want the child to just be going through the motions. We want them to thrive. We need to make sure that the deaf child feels academically challenged, that their intelligence is being challenged, and every year they're progressing year after year on time, and they're able to grow and thrive, like we said. So a lot of times, school professionals don't fully understand deaf education. Sometimes the average educational teacher sees a child once every 7 years, so they may not particularly be an expert on deaf education. So the family has to remind the professionals in the school about having high expectations for their children. And one key document that will help you is if you look at the state standards, the curriculum for education. So if you look what kindergartners are supposed to learn in math, in reading, in science, you also look at the child's homework, their classwork, their IEP goals, and see how they line up. If it's the same skill set for that particular age of the child. You really want to check in and see if perhaps there are older children, see what they're learning in 4th grade, see if your student is also learning that in their 4th grade program. Is your child's program too easy? And then you can have a conversation with the school about it. See, is it that my child has a learning disability, or is it just that my child is deaf that you're giving them this easier curriculum? You can communicate directly with them and just acquire as much information as necessary so that your child is progressing on grade level. Again, it's good to have those check-ins. There are also a lot of disputes I see often with transition coming from the IFSP to the IEP for the first time at the age of 4. That's something we see a lot as well. If a child is doing too well almost, if their language is developing from birth to 4, sometimes it's felt that the child does not qualify for an IEP. because of how other language is doing. But the child still needs supports. There are still specific services that are required to help them continue that success. So sometimes families need to, again, push and make sure that the child is still qualifying for special education services. I highly encourage you to make sure that you're very careful during the transition phase with 504 that you get ADA, that you're not getting ADA services only without the IEP. We want to keep the family's opportunity to provide their input and feedback and be a part of the decision-making process and have the opportunity to increase services for their child as needed. So that's something to definitely keep in mind about continuing services that you receive, because it may be different under the IDEA as opposed to the Act 504 plan. They're both very different. So you want to make sure that you're aware of what your child's needs are. And if they're not transitioning from an IFSP to an IEP, you want to get this into the IEP later. So just make sure you keep that in mind, because that's something we very often see. Parents are sort of just thrown into a situation when you have to think about the child's ability to interact with their peers, their autonomy, their ability to engage in class on their own, and know what their rights are as a deaf child. That's why we need these in the IEP goals. They may be doing fine academically, but there are sometimes that those things that parents need to include so that the child continues to have their success, and those things are documented in the IEP. So again, those are some disputes that we see, whether or not a child can even have an IEP or not.
Thank you both. I thought those were great answers, and I agree with what you said. I think that wraps up our session here today, but I look forward to talking with all of you more and wish you the best of luck.
Thank you, Jenny.
Thank you.
Thank you, Jenny.